Hello, this is Monica Chow. I'm going to give some comments on the assignment that you have made in the that you've delivered before last week. You had a case, the bridge in Genoa, and the question was who was responsible, who was liable for the damages that are caused by the collapsing of the bridge. And what you first have to think about then, when you look at a case like this, is how could the bridge collapse? What were the causes leading to this event? So two factors came in view, given the information, the very limited information that was given to you. It could have been a design mistake made by the designer, and or it could have been an execution mistake. Both things can occur together, but they can also occur, only one of the two things can have occurred. In this case, it was not given which contract model governed the situation. That means you had to talk about two possible situations, the traditional model or the design and build model. In the traditional model, the employer has a design made by a designer and he gives that design to the contractor. That means legally, in the relationship of the employer and the designer is responsible and liable for the design because there's a contractual relationship and the designer in that relationship did not do what he had to do, and that means that he is, for the other contractual party, the employer in this case, he's responsible and liable if there are mistakes. In the relationship of the employer and the contractor, the employer is responsible and liable for the design because it is the employer who gives the design to the contractor and says to him, execute this design. If there are mistakes in that design, then in principle the employer cannot hold the contractor liable for those mistakes. But there's one important issue in this matter, and that is that the general conditions say the contractor has a duty to warn for obvious mistakes. The question is, of course, what are obvious mistakes? You can say something in your answer about that. That's all written in the book. The thing is this: if there is a design mistake, the designer will be liable for his mistake. But if this is combined with a failure to warn by the contractor will be liable for the consequences of his failure. Meaning that if the designer made a mistake and the contractor violated his duty to warn, the contractor, by that mistake, is not becoming liable for the design mistake as such, because that mistake has been made by the designer. But the contractor is liable for the consequences of his failure. So imagine we have a design mistake, the contractor did not warn against that, we find out that there was a mistake, it has been executed and now this has to be redone. Then the costs of the mistake made by the designer are for him. So for example, instead of 5 pillars underneath a building, we need 6. Then having to, now we need, so the 6th pillar has to be there, but making a 6th pillar under the building would have been a lot cheaper if the contractor would have warned. If he would have warned, for example, before the pillars were put into the ground. Now, because the pillar has to be put into the ground after the building has been erected, that will cost a lot more than the original reparation of the mistake. For the original reparation of the mistake, the architect is, or the designer is liable, but because the concrete has become more expensive, the building is there already, so technically it's a lot more expensive to put the pillar underneath the building. Those extra costs are the consequences of the mistake of not having warned in time, and those mistakes are for the contractor. Then we have a look at for how much are both parties liable. The liability of the designer is in a general condition limited to once or 3 times his fee. They have to agree upon that before entering into the contract. So that is a very important limitation. But there is another limitation which is very important. The designer is only liable for the direct damages. So imagine in the case of the bridge collapses. So these are direct damages. The concrete has to be moved away, all the buildings that have been destroyed, those are direct damages. But imagine the bridge was a bridge for which you had to pay. And now, because the bridge is damaged and cannot be used for 3 months, for example, then those damages, the loss of income because of the money that has to be paid to the employer for using the bridge, that is indirect damages, and for the indirect damages the designer is not liable. If the contractor made an execution mistake, so we're not talking right now about the warning mistakes, but just an ordinary execution mistake, and that mistake was not discovered at the time of takeover, nor should it have been discovered at the time of takeover, then he is liable for the damages in full. So for hidden mistakes, the contractor will be liable in full. If it was not a hidden mistake, it should have been discovered at the time of takeover, then he's not liable at all. The contractor is also liable for the consequences of his failure to warn, which is not an execution mistake as such, but is a warning mistake that has some kind of an administrative nature, you might say. Then for those damages he will be liable in full, but remember that the damages do not include the original mistake. Those are the damages that the designer has to pay for. And in both situations, both the liability of the designer and the liability of the contractor is always limited in time. Then we deal with the same case with the integrated model. If the bridge was made according to the integrated model, the legal situation is somewhat simpler, because the contractor is responsible and liable for both design and execution towards the employer. This is also the case if the design was made by a designer outside of the organization of the contractor, but who was used by the contractor. So the contractor cannot say in an integrated model to the employer, I'm not liable for a design mistake because the design was made by somebody else, because he used that somebody else. Then there is another thing. If the mistake could have been discovered at the time of takeover by the employer, the contractor is not liable, so he is not liable for hidden mistakes, if it could have been discovered at the time of takeover. If the mistake was discovered by the employer during the works and he didn't warn the contractor, then the contractor is not liable either. And the liability is always limited in time. In the case of early contractor involvement, we have the special situation that the contractor takes part in the design. In that case, the contractor is not liable for the design as such, but he is liable if in the design there is a mistake that is due to a suggestion that he made. So if the contractor comes in the design phase with a certain suggestion, do it like this or do it like that, and that turns out to be a wrong suggestion, then the contractor is liable for his suggestions. However, if the suggestion of the contractor has been accepted by another team member in whose field the suggestion was, so for example, the contractor came with a suggestion in the field of the architect, and the architect says, that's a very good idea, I accept it and I embrace it as if it was my idea, then the liability for this idea shifts from the contractor to the architect. Also, this liability is limited in time. Now, another question was on the defense of the designer. If the employer says, with the collapsing of the bridge, I hold you liable, then what can the designer use as an argument to get away from this liability? He could say, listen, you hold me liable for all the damages, but my mistake was a mistake the contractor should have warned against. So, if he can prove that the contractor did violate his duty to warn, then the liability of the designer will be limited by the liability for the violation of the duty to warn by the contractor, as we saw in the first question. That is the main defense that the architect, the designer can use. The damages that are the result of the contractor violating his duty to warn are not for the designer, but have to be borne by the contractor. Also, what the designer can say is, well, I didn't make a mistake at all, my design was perfect, but the mistake was an execution mistake. If that is the case, obviously he is not liable either. Then the procurement law question. That question was aimed at the students going through all the procedures. The tender procedures that you can use, you had to mention, you had to describe them, and you had to describe them and think immediately about the special characteristics of the case. Because the case had a few specialities, like it was a difficult and complex assignment that the city had, the situation in which you have to work in the middle of the city, with all the traffic, all the people living there, all the cables there. This was a very special assignment that the City of Amsterdam put out to the market. So which procurement procedure is fit for that? Given that complex question, which tender procedure is then the special, the best procedure? Now you can discuss about that answer, but what you had to do was go through both aspects, from the procedures and from the case itself. And then there were several possibilities, so not one answer was really wrong. The only answer that was actually not very much to be expected would have been if you would have said, well, let's use the open procedure. The open procedure would have been somewhat of a silly answer, but if you could defend that properly, you had good reasons for that, that would have been accepted too. But not one particular procedure was needed, but I did expect all students to come up with the restricted procedure, the innovative partnership, and the competitive dialogue. Those procedures were things that you really had to mention. The mistakes that were the most made were that the answers were not complete, were too short. You could have said a lot more about it. I'm now giving you only the nucleus of the answer, but you could, in your paper, you could have been very extensive with the answers, several varieties you could have thought about. You could have mentioned articles that you found in the book, and you could have used better, clear language. And what is very, very important, the moment you deal with more than one person in a case, so we have the employer, we have an architect, we have a contractor, then you must always be very clear which person is suing whom, which relationship is applicable in this particular relationship between the employer and the architect, between the employer and the contractor, and maybe between the architect and the contractor. You have to be very, very specific and very clear. I hope you do well during the test. The questions were not made very badly, so this is a good start, a good preparation for the test, and I wish you good luck with that. Thank you for your attention.